All right, so how is everybody tonight? Ooh, great, huh? So, who here wants to freelance? Can I have a show of hands? All right, who here wants to be employed? All right, we're going to cover a little bit of both. So, if you're a freelancer, you're taking a lot of the liability on yourself. One of the things that you can do to get rid of that liability, or at least lessen the liability, is to become, say, a corporation. That's something that I've done, and that whenever I do any artwork for someone else, the corporation takes the liability. So that if for some reason I get sued or the corporation gets sued, they come after the corporation, not my own personal property. Now, if you work as, say, a freelancer, does anybody know how long it actually takes for a business to, like, become established? Just how long? 5 years. So if you're planning on working as, say, a freelance artist, realize that you have about 5 years of work ahead of you to establish yourself and your work in your respective field. How many businesses fail within the first 2 years? About 60%. 60% of businesses fail within the first 2 years. So, like, that's something that you should be aware of if becoming a freelancer is something that you really are gung-ho about. Now, if you're an employee, if you're working for somebody else, the employer is taking authorship of your work. Does that sound like a good thing or a bad thing? Both. Why would it be both? Okay. You might get health benefits. What else? They own your work. That's bad, right? Okay. So, when you think about, like, say, the ownership of your work, like, you got your handwriting, like, basically taken from you. So you didn't like that, did you? No. Okay. Okay. Is this working?
Sounds great.
Okay. All right, the first thing I want to talk about is negotiating contracts. Negotiating contracts is something that I've had to do, and it's like scary as all get out. It's about as scary as standing in front of you guys right now, because there's like tons of you and it's terrifying. But like negotiating contracts is just about that scary, and you're going to have to do it. You're going to have to do it if you're freelancing, and you're going to have to do it if you're, say, becoming an employee of somebody, all right? The first thing that I had to do, the first contract that I had to negotiate was my pay. I had to negotiate my pay at the very first job that I got outside of art school. Now, that's something that I didn't really learn how to do in art school, is just negotiating. That's something that, like, I talked to just friends of mine and they said, oh, you can negotiate pay? And I said, really? You can do that? And they were like, yeah, I negotiated pay. And so what I did in my first job, they offered me a certain pay amount. And I said, I'll have to think about that. Can I get back to you, in a few hours? And, I did. And I made a counter offer. So I countered and I say, this is what I'd like to get paid. And then they said, well, we'll have to think about that. Actually, they didn't say that. They paused for a second. And then the guy, the art director that was offering me the job, he said, well, I think we're going to have to resend the offer. And I said, wait, no. And he said, oh, I'm just kidding. And I was like, oh, you jerk, But like that was my first experience in negotiating. But basically what happened is I offered a certain dollar amount. I asked for a certain dollar amount. They got back to me and they said, no, we can't do that. But this is what we can do. If you perform well for, say, 6 months, then we'll give you what you want. We'll have a review, and if you do good, we'll give you what you're asking for. So I said, okay, that sounds great, and I accepted the job. Now, that was my first experience, but it definitely wasn't my last experience. Now, one thing I want you guys to really get in your mind is that your work is valuable. Your work is very, very valuable. If anybody is hiring you for an employee position or a freelance position, whatever, they want your work because they want to make money off of your work. So, your work is worth money to them. They would not be hiring you if they didn't think that they could make money off of your work. How many people are in here? Like 200? Every person's artwork in here is individual to them. The artwork that I turn in to a client is going to be different than the artwork that you might turn into a client. So the type of work that they're getting is very specific to you as an artist and as an individual. This is important because it gives you guys the power. The way I like to think of, say, negotiatings or even contracts is like it's a game. It's a big game. You're playing cards. Now, the thing that you've got to realize is that you have the winning hand because you've got the goods. They want something from you. You've got the winning hand. Now, the thing is that it's scary. It's scary negotiating. It's scary saying, well, I know you want this, but, you know, I want this. And waiting in that uncertainty. And one of the things that's probably, I guess, the best thing that you have in negotiating is awkward silence. Awkward silences are good. They are not bad, they are good. If there is awkward silence in a negotiation, that's a good thing. And if you break that awkward silence, you lose the negotiation. Do you understand? So, when there's an awkward silence, shut up. Don't say anything, okay? Because the next person that talks is the one that loses. All right? Now, let's talk a little bit about like the rights to your work. Everybody wants, the copyright to your work, right? Yes? Yes, okay. That's good. But some contracts, what they do is they kind of throw you a placebo, where in the contract it'll say something like, the artist will retain the rights to their work. And like you feel real good because you see that line in a contract and you're like, yeah, it's my work, I retain the copyright. But then they'll go on to list all of the things that they can do with the work itself. So they want to be able to print, merchandise with the work. They want to be able to print it worldwide. They want to be able to, put it on the internet. They want to be able to sell your work to a third party. And then they'll go on to what you cannot do with the work. You cannot sell your work to a third party. You cannot use your work for promotional purposes. You cannot do this, that, and the other thing. Now, what good is, say, a copyright to your work if they're stripping all your rights away in the contract? Do you see what I'm saying? So that's something that when you look at a contract, you need to assess and you need to negotiate. You can negotiate like full right, full buyout. They get everything, and that's good, that's fine, as long as they're willing to pay for it and pay dearly, okay? Because remember, they are going to make money on your work. That's why they're contacting you. Does anybody here know what work for hire means?
Selling all rights.
You're transferring authorship of your work to somebody else when you sign a work for hire contract. Now, work for hire sounds like I'm working and you're hiring me. That sounds reasonable, But you're transferring authorship of your work. Everybody here knows Gary Barker, right? Gary Barker does Garfield. But who signs their name to the Garfield comic strips? But wait, Gary does the work. John Davis is claiming authorship of the work. Now, Gary's trading something else for the transfer of the rights to the work. What he's trading is security. And security is a very good thing. You want security. But when you're negotiating your pay and your rights, you're going to have to think about what exactly it is that you're giving away. So, one of the reasons why I might sign a, say, work-for-hire contract or agreement would be if I'm doing Mickey Mouse. I'm not going to be able to do anything with the Mickey Mouse image that I create. There's nothing that I could do with Donald Duck where I could, stick it on a t-shirt or put it in a book and make money on it, because Disney would kill me. So what good would it be to me to retain the rights to that work? But the problem is when you're spending your time doing, say, work-for-hire assignments or working for an employer, one of the things you've got to consider is the opportunities that you're passing up. If you're taking on a work-for-hire assignment, you're passing up opportunities to do work where you retain the rights to the actual work that you're producing. One of the good things about, say, what I do is my work generates a lot of passive income, where I will continually be getting paid for work that I've done in the past. Now, when you do or create contracts that generate passive income, whether it's through percentages or whatever, it will pay off and they will add up, because you do work, 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 and you do more work, and the percentages start to add up and add up and add up and add up the longer that you work. Especially if you're doing something like, say, apparel design, where you might get 2% or 5% for every design that sells. And that's something that needs to be and can be negotiated in your contract. All right. I did some work for this company called Ogilvy and Mather. Anybody heard of them? Okay, they're a large advertising agency. They contacted me about doing this job for, it was for Pampers or Huggies. But it was this kind of fun job where I drew this mom and this daughter doing this potty dance. And I negotiated a pretty good contract with them. It was a good deal. And I did the work, I sent it off to them, and they sent me a purchase order after the work was completed, after it was totally done. And the purchase order had, in little fine writing on it, that by signing this purchase order, you are transferring the authorship of your work to Ogilvy and Mather. But the only way to get paid was to actually sign the purchase order. This is after the contract has been negotiated. This is after the work has been done. Now, the contract that I negotiated with them was a buyout. They got all the rights. So I was like, oh, who cares? But if that ever happens to you, if you ever find yourself in that situation and you did not negotiate, say, a buyout, you contact the company. You contact the company and you say, I just received a purchase order. It says that I'm transferring the authorship of my work. I didn't negotiate this in the contract. If this is something that's important to you, then you need to pay me for it. Otherwise, you need to issue me a new purchase order. Okay? One of the things that you also need to have in, say, a contract is you need to know when you're going to get paid. Getting paid is important, right? Yeah. What happens if your contract doesn't mention when you're getting paid? Then they can drag their feet paying you. Some contracts will say net 30, some contracts will say net 60. So that might be 30 days they take to actually pay you, or 60 days they take to pay you, 2 months. 2 months is a long time to wait when you need to pay your bills, when you need to eat, when you have a mortgage, when you have insurance. Generally, what I do is I negotiate half up front, half upon completion. If they're not willing to do that, I walk away. If it's a really large company, then I'll stick around. If it's something like Disney, then definitely I'll stick around because I know that they're good for it. But if it's a little mom and pop shop, if they're not a company that's established, then I want 50% up front or I don't do a darn thing. Because too many times, companies or people will hire you, they'll get sketches, they'll get ideas from you, and then they'll just walk away. And like when you really think about it, like a contract is awesome, but it's hard to enforce. I don't want to go to court. Do you guys want to go to court? It's not fun. Going to court is not fun at all. So like, make sure that unless you're dealing with a really established company, that you're getting something up front, just so that you have something if they decide to walk away. I like to think of contracts as like a fence. Fences are good. If I have a bad neighbor, guys, I have a really bad neighbor, he's a jerk. I hate him. But my fence keeps him out of my backyard. Fence says, neighbor, stay over there. And he stays over there. He doesn't go across my fence. Well, maybe he throws oranges at, my chickens or something. But like, the fence kind of keeps him out. And that's what a contract is. A contract is a fence. It lets you know where your boundary is, and it lets them know where their boundary is. Now, if say your artwork, you do a cover illustration for a magazine, and in the contract it says something like that you can post it on the internet or you can do whatever with it once this magazine has been published. What happens if it isn't published? You can't post it. You can't do anything with it. What happens if the company goes under before your work is published? Can't do anything with it. It's in limbo land. What I like to do is I like to give a time limit to the actual artwork. So maybe within a year, 2 years, 3 years, pick a number, whatever, from the date of this contract, all rights revert back to me. So like if you do have something where a company is taking your artwork, where they're publishing it and they're dragging their feet, or they go under, or they decide to go with something else, and your illustration doesn't see the light of day, that you'll get the rights to it back. That it's not stuck in limbo land forever. Now, if you work for, say, Hallmark or American Greetings, you're probably going to sign a non-compete clause. It's basically a clause that says that you can't compete with the company. And usually there's specific things that they don't want you to compete with. I had a friend that worked at Hallmark, and she got a job doing this like little children's book. And what she did for this children's book is she worked on it with her boyfriend. He actually designed the book, and she did the illustrations for the book. It was like a little green Santa book. It was a great, fun little book. Now, the person that she worked for was like, she thought was one of her, friends. It was somebody that she trusted and she got along with. And she didn't really understand what kind of contract she was signing, but she signed a work for hire contract. And she thought that because this person was very friendly, because they were very personable, that everything was going to be okay, you know, and they would take care of her. Now, because she signed a work for hire contract, she transferred the authorship of her work to this person. That's not a good thing at all, especially if you're working for a large companies like Hallmark. Now, what happened with this book is she made it, her boyfriend designed it, and then Al Gore promoted it on the Today Show. And the book went crazy. It was everywhere. Now, Macy's made this huge display in their New York store about this book, and they made little plush toys and all kinds of stuff based on the illustrations that she did. Now, her art director went to New York and was taking a business trip in New York, and her art director and her were kind of buddy-buddy. And so her name was Myrna, and she got a little text on her phone with pictures. And it was a text and pictures from her art director. And it was saying something like, "Have you seen this?" And she looked at the pictures, and the pictures were in Macy's. It was Myrna's artwork blown up huge, and it was pictures of all of the displays in Macy's in New York. And Myrna was like, "Oh my goodness, oh no," because she knew that what she had done was against the non-compete clause in her Hallmark contract. And so she did something really, really smart at this point. And she ran over to the legal department at Hallmark, and she basically pled poverty and said, "Look, I messed up. I didn't know what I was signing. I don't know what to do now. Please help. I didn't mean to do this. I didn't mean for this to happen." They said, "It's okay. It's all right. We'll look the other way, but don't let this happen again." She could have lost her job because of that. She's still working at Hallmark. She's doing very, very well for herself, but that was a big faux pas that could have bit her in the butt real bad. Now, one of the things that happened to me at the beginning of my career is that I got really lonely. Really, really lonely. And the thing is that like I got hired for, you know, a full-time position, and that was fun. I worked there for about a year, and I got this opportunity to do this children's book. But in order to take this opportunity, I had to quit my full-time job. I had to quit it. And my wife was pregnant, and we had a decent amount in savings, but I would basically have to go into free fall. And it was terrifying. It was really, really scary. So I quit my job, and I started freelancing. Now, I didn't realize just what kind of, you know, art community I had in the studio that I worked. Or say the art community you have here at Ringling. You're surrounded by artists. It's awesome being surrounded by artists. But when you're freelancing, it's just you. That's it. You're sitting in front of a computer, you're sitting in front of a canvas, you're doing whatever it is you're doing, and you don't get that kind of positive reinforcement. Keep going, you're doing good, that you might get here. There's nobody to keep you moving, it's just you. And it gets really lonely. And you start to wonder, does anybody care about my artwork? Now, this is really dangerous because there are predators out there that will prey on you because they know how lonely it gets. Let me just give you an example. All right, so I'm sitting at my desk, I'm working on whatever project I'm working on, and I get a phone call. And this really, really happened. This is a true story. Get this phone call, and the person on the other end of the phone says, "Hello?" And I'm like, "Hello, this is Caleb." And they're like, "Oh, is this really Caleb Prochnow?" I said, "Yes, this is Caleb Prochnow." They said, "Oh my goodness, I just love your artwork." And I'm like, "Oh, somebody cares." I'm like, oh, thank you. And they're like, oh, no. I mean, the work on your website, it's just incredible. I don't think I've ever met anybody so talented. And I'm like, oh, thank you. And they go on and on. And like by the end of it, I'm this little puddle on the floor. And then comes like the dangerous part. They say, you know that piece of artwork on your website? Like, yes. You know, the one with Popeye? Oh, yeah, I know that one. Can we use it for a cover to our magazine? Oh, that would be fantastic. But we can't pay anything. Oh, take it. Now comes the part where like I have to pay the piper. Because I leave my office feeling awesome because this guy just like totally buttered me up and made me feel great about myself. And I walk into, you know, the bedroom where my wife has, you know, our newborn son. And I'm like, baby? And she's like, yeah? And I'm like, guess who's going to be on the cover to a major magazine? She's like, oh my goodness, you are? And I was like, yeah, it's me. And she's like, so what are we getting paid? And I'm like, self-promotion. And she's like, no, we can't eat self-promotion. And like, this happened maybe 3 or 4 times. Like literally 3 or 4 times where someone would call me and they would just like heap on the compliments and I'd just be like, oh yes, tell me more. Tell me how good I am. And then they totally like swindle me. And it got to the point literally that my wife would like burst into the room after she heard me say thank you 3 times. If she heard me say thank you 3 times, she'd burst into the room and she'd start like doing this neck chop thing. And so that's when I was like, okay, I gotta get serious. Now, yeah, when people compliment you, when they compliment you, watch out, be on your guard. Because if they're a business, if they're just wanting art from you, they're not going to butter you up. They're just going to be like, hey, I want this. I like your work. You're good. Do you want the job? You know? So if they lay on the compliments, oh my goodness, watch out. Bad news. All right. One thing that also happened to me is I got this job designing a cover to this comic book, and I was really excited to get the job. And I signed a contract, and I finished the cover. I gave it to them, and they told me that they're getting it printed, and they were getting it printed on. You know, has anybody been to like MegaCon? Well, they were getting it printed on like the MegaCon thing that they hand out to everybody. And I was like, oh, that's fantastic, that's great. But it was on like the back cover. And I went to MegaCon, I was super excited because I was going to get to see this, you know, cover that I did at MegaCon. But the thing is that the designer thought that the work would look better if they mirrored it. It's horrible. So they mirrored my artwork and it looked like crap. But they didn't just, you know, put it on the back cover of the MegaCon thing. They got this like freaking huge banner and put that, you know, at their booth. And they also got an advertisement like inside the thing with my artwork, and it was, you know, mirrored as well, and it was just a horrible experience. But the thing is that what I should have done is I shouldn't have given them the right to modify the work. They don't have to modify your work. You can retain the right to modify your work. So if I'd written out a contract that said that they had no right to modify the work, then they would have had to go through me to get the work modified. And I would have said, no, I don't want this image mirrored. I want it to stay just the way that I drew it. You also want to watch out for exclusive use. If someone has the exclusive use to use your image, then nobody else can use your image. So if you're going to sign over the rights for them to have, say, exclusive use to your image, you're going to want to make sure that you negotiate a good deal. One of the things that I also ran into is like blanket contracts. Blanket contracts are contracts that govern all future contracts, that govern anything that you do for a company. So let's say you're just out of school and Coca-Cola contacts you and you negotiate a contract with them, but you sign a contract that says, you know, after this contract there will be no further negotiations. This is a contract that will be used in all future dealings with, you know, the Coca-Cola company. But the rate that you're negotiating with them is something that you're doing as not an established artist. You're not an established artist. You're not like a powerhouse in your career yet. So maybe 6 or 7 years from now, when you've established yourself as an artist, you might have the ability to negotiate a better rate. But do you think they're going to want to negotiate with you when they already have a blanket contract signed by you? Heck no. They'll just want to go with that contract that they already got. What I like to do if somebody wants me to sign, say, a blanket contract, is I want to limit the time that that contract is good for. This is good for a year. This is good for 1 year. After that year, you'll have to negotiate again with me. Now, if somebody doesn't pay you, that really sucks. They're not paying you. But if somebody doesn't pay you, it would be really nice if you were getting interest on the work or on the money that they would owe you. So one of the things that you can do in your contract negotiation is you can establish when you're getting paid, and if they don't pay you, interest that they'll owe you. I have this one guy that does a lot of work for my company, and his name is Alex Alekos. He's a graduate of Ringling. He does some design work, some like website stuff. And one of the things that he does is he'll send me like an invoice for whatever work he performed. And on the invoice it'll say, you know, if this isn't paid by this date, then 10% interest, you know, is due. That gets me paying him really fast because I'm like, oh my goodness, I don't want to pay him more. Here's your money, take it, take it. A kill fee. What if they don't like your artwork? What if you send them, I don't know, sketches or something? They look at the sketches and they're like, we don't want to use you. We're going to go with a different artist. A kill fee is when they're deciding to scrap the project. There was a guy that taught here named Sean Barber. Sean Barber did a Kid Rock CD cover. Sean Barber got paid $5,000 when the job was canned, because that was the kill fee that they negotiated. He actually negotiated a $5,000 kill fee. And what happened was Kid Rock saw his art and said, you know what? Let's use a picture of me. And they were like, okay. And so they paid Sean Barber $5 grand. Yes.
How much would he have gotten paid if they had used his art?
$5 grand. He was pretty good. But that's one of the things that I do, like especially with like the getting paid half up front. That's kind of my kill fee. If they kill the job, then I got half, so I'm good. What's up?
Do you normally negotiate kill fees when you first negotiate the contract with your employer, or can you negotiate that later on?
Oh, this is basically the way it works. Like, y'all have gone on dates, right? Yeah. Okay. like negotiating contracts, especially when you're talking about like pay and nitty-gritty details, like going on a date. You know, you don't kiss them until after the date. You know, you talk first. You act interested. You know, and then you could go in for the kill. You know, so it's like you're negotiating. You're talking. It's like if somebody calls me and says, "Hey, I've got this job for you," I'm not like kill fee. You know. You know? I'm like, so tell me about the job. Yeah, and like sometimes I could care less. I mean, it's like it's freaking, you know, Pampers or Huggies, and I'm like, shoot me, you know. But like I'm like, oh yeah, sounds great. Yeah. The diaper dance. Yes. No, I haven't seen that commercial. You know. So you act interested. You talk to them, and then after you've kind of reeled them in, then you start negotiating. Then you start like hardlining them about money and about the details of the contract. Usually, if you're working for a large company, they have a contract they're going to send you. So they're going to send you a contract. You're going to look it over, and then you're going to make amendments to that contract. You're going to strike things out. You're going to tell them what you want changed, and you're going to write it up. If you're working for like smaller mom and pop companies, you're probably going to write the contract yourself from scratch, and then you're going to send it to them, and then they're going to tell you what they want or don't want, what they might want to change. But expect some negotiation. All right. Let's see. What else I got? 5-minute warning.
5-minute warning.
Okay.
You gotta kill me.
Thank you, Jeff. Appreciate it.
Awkward silence.
Okay. Yep. They're good. Awkward silences are good. Okay. I want to talk about liability. I got this contract that like scared me, and like it scared me because it said that this is what it says, that the artist represents that the work is his/hers, and it does not infringe on someone else's copyright. How can you know that? You know, like seriously, there's so much work being generated by like other artists out there, past, present, future, whatever. Like, well, past and present is all you got to worry about. But like, you can't really know that with all certainty. So like, what I did for that contract is I added some words to the best of the artist's knowledge and belief. I haven't infringed on anybody else's copyright. I would not sign a contract that says all actions arising from the artwork. It says all actions arising from the artwork the artist is liable for. What? So do y'all understand why that would be a bad thing?
Because we'd be liable.
Yes. Let's say they take your artwork where you're not infringing on anybody else's copyright, and they stick a giant Mickey Mouse in the dead center of it. And then they sell it. And then they get sued. And they're like, hey, this artist over here, they signed a contract that all actions arising from the artwork they're liable for. They're the scapegoat. So like I would just simply not sign a contract like that. The longer the contract is, the scareder I get, honestly. Like I once got a contract that was like 12 pages long. 12 freaking pages. Usually contracts are like, 1 to 3. That's okay. 12 pages is like, heck no, that's just terrifying. And like that contract I read at least 10 times. And like I did find something in it, and I was like, I can't sign this contract. And they wouldn't negotiate with me either. They were like, nope, that's a contract. It's like, well, forget it. I don't want to work for you. Okay? So like usually the longer the contract, the more I'd watch out. Okay. That's it for me. I'm good.
My background is that I am an artist. I was a freelance artist for a while. I was married to an artist. It's very hard to find two artist jobs in the same town, if you will. I went on to become a librarian, and from that combination of art and librarianship, I took an interest in copyright as it relates to the kinds of passions and careers that we all have. I have a colleague, Jennifer Friedman, who is in the audience as well. She's in the top row. Jennifer is up there. She's also a copyright specialist. You may have already talked to her about copyright during this year. Always this disclaimer, this is sort of my verbal contract. I'm not an attorney, and the advice I'm giving you is not legal advice, but it's based on an understanding and a reading and my interpretation of the parts of copyright law that are open to interpretation. You have faculty members who've been sharing with you for a long time copyright information as well, based on their practice and their understanding, and they bring another kind of perspective on what copyrights are, what you can do with them, and so forth. So use all of the knowledge that you have at hand, because copyright is one of those areas where some things are absolutely clear and the rest are either murky or open to interpretation constantly. Jake, is that Jake over there? Where's Jake? Thank you, Jake. About 2/3 of the way through, I'm going to invite Jake Giddens to come up to talk about an intellectual property issue that he encountered recently. You may know his story already, but I want you to hear it from him. Okay? All right. This is the breadth of copyright and intellectual property that you're most likely to run into. I put copyright at the top because it's the one that we talk about the most, but sometimes that's confused with trademarks, meaning logos and things that stand for business practices. Patents, those are useful processes or objects. Licenses, and Caleb referred to some things that might fall into the area of licensing. Artist moral rights, does someone have a right to change your work? Do they have a legal right to do it? Do they have a moral right to do it? Then there's this other category of things that are very assorted. On the left-hand column, everything but licenses are related to federal law. Licenses are part of contract law, managed by states. Trade secrets, trade dress protection, right of publicity, right of privacy, those are covered by state laws too. And the states also have some copyright issues as well. Is there anybody who didn't draw something today? How about a show of hands for everybody who did draw something today? You are so well prepared. I thank you for preparing for this lecture. All right, the first question, a question that came up so constantly in amongst those you sent was about how do I get a copyright? Congratulations, anything you drew today that was original and creative is already copyrighted. Let's have a party. Okay, good. All right, this is a great change in the copyright law that came within the last 2 or 3 decades, where you did not have to register your copyright in order for you to have copyright protection. So it's automatic. You don't have to do anything, and it's immediate. It happens as soon as this happens. You have to do what they call, I love this, fix it in a tangible medium, which sounds like a biology lab experiment to me, but it actually means that you have to write it down, film it, record it, save your file. It has to be something, not just spoken. Have you had a conversation with anybody today about a great idea? Yeah, okay. Well, if you didn't write it down, but they thought it was a swell idea and they wrote it down, guess who's got the copyright? All right, so did anybody lose a friend just now? All right. Now, while they may own all of a sudden own the copyright in it, there might be a moral or an ethical issue there. that we could discuss. So it's not all about laws, it's also about what our professional practice is as it relates to other people. It must have some sort of originality. Did anybody draw a smiley face today? Guess what? Oh, we have one. Well, if you were counting on making a lot of money on that smiley face, I have to disappoint you because the smiley face is in the public domain.
Shoot.
Yes. If anybody drew a smiley face and put a sombrero on it and gave it a mustache, and if nobody else thought of that, congratulations, you have a copyright. You don't have to renew it either. And I say these things about being immediate and automatic because there was a time when you had to do those things. You had to register and you had to renew it, and you had to keep up with your renewals because guess what happens in those days when you don't renew something? It goes into the public domain. Nobody else can do a copyright of it either. Okay. And having a copyright is not the same thing as registering a copyright, which I think is where some confusion often comes up. All right, how long does copyright last? So do this. Take your age, and I'm going to bless you and say you will all at least live till the age of 90. If you don't wish to live till the age of 90, you can keep that to yourself. I have to tell you, I was...
With linseed oil and cadmium.
Okay. I was at a website lately where you're supposed to plan for how much money you need later in life. Okay? And I read several of these because I'm already later in life. And one of them said, decide how long you're going to live. This is in order to calculate how much money you need. So I was by myself and I was at the computer, so I said, I'm going to live until I'm 90. Nobody said otherwise, so I went on with my financial planning. Okay, so take your age, subtract it from 90. Somebody tell me what number you got just there. 70. Somebody is age 20 here? All right, now add 70 years.
140 years.
That's how long your copyright in what you drew today lasts. 140 years. But I didn't tell you you could live till you were 140, so watch out, okay? Okay. All right. And that becomes part of the problem when we're trying to use other work that's previously been copyrighted. It lasts so long now. And this is when it all started. Copyright is vested in the concept in the Constitution of the United States. We're not the only country, we're not the only society that has copyright. And a lot of ours is based on English law, and that makes a lot of sense because that's how our founding came about. And in the early years, copyright lasted 14 years, and you could renew for another 14, so you could have 28 years if you went through that. And this made sense when you understand that the average lifespan was 35 to 41 years. So 28 years, so let's say they're 20. The person who's writing is 20, and they get 14 years, and they get another 14 years. It should last them their whole lifetime, if not more. As of today, we're up to the 70. 70 years plus our lifetime. Corporations can also have a copyright, and that copyright can last 95 years. There's no plus the life of, there's no extension or renewal on that. It has to do with when it's created. So at minimum, what Disney creates today will last 95 years, unless they haven't published it yet, and then it will last 120 years. Yes?
What if the company that has the copyright goes under?
The copyright doesn't die with the company. It is an asset. It's considered property. It's sometimes difficult to track down who still owns that property. But copyright doesn't die with the person who created the work, and it doesn't die with the company either. Yes?
If you were to say make your own personal corporation that's pretty much just yourself, and then make a work could you consider that for hire for your corporation and get this extended copyright?
You can either be a corporation or you can be an individual on the day that you are doing your copyrighted work. In other words, if you're going to work as a corporation and you're doing work as yourself, Inc., then more likely your work is the 95 years. Were you going for the long haul there? You were looking for the 140 years? Probably. All right, what can you copyright? Okay, in the left-hand column, all those things should not come as a surprise to you. Books, journals, art, sound recordings. Did you know you could copyright computer programs? You cannot copy type fonts. We haven't protected that in the United States yet, but you can copyright a computer program that can generate type fonts. Architecture, blog postings, your email, the letters you wrote your mom, all those things can be copyrighted. They're copyrightable, I should say. That copyright happens immediately. What can you not copyright? You can't copyright a name or a title or a common idea. You can't copyright the names of the states or the names of the days of the week or just general facts or what a ruler looks like. Those things are all in the public domain. So those are not available for copyright. Otherwise, we'd all be pretty much bound up. We'd have to go to the copyright holder every time we wanted to mention those things. Trademarks are different. Logos can be a name, so you can get a trademark on a logo, on a name, and make it into your logo. You can copyright symbols, designs, slogans. How about, he just keeps on going and going and going. Who's that? The Energizer Bunny. How's that? That's a copyright. Finger looking good. KFC, right? Those things you can trademark. I don't know what I just said. I probably said copyright, but those are things you can trademark. The MGM lion is a trademark object, and his roar. Have you ever heard him roar? That's trademarked. Okay? You can trademark fictional characters. We know that. Mickey Mouse walks around with the trademark all the time that we can't use. You can trademark a service. Yes?
Why is it that the MGM logo is trademarked and still copyright? If it's like if the video of the lion making that roar, why is that trademarked instead of copyright?
I'm hearing the first part of your question and not the last. Why is the roar trademarkable?
Yeah, no. Why is the video of the lion with the sound of the roar trademarked instead of copyright specifically?
Oh, something can have more than one protection. Mickey Mouse, a picture of Mickey Mouse can be copyrighted, and Mickey Mouse as a visual can be trademarked. The MGM lion, that video at the beginning, that can be copyrighted. And using that, I can't remember what the circular shape is that his head comes out of, the MGM lion, that can be a trademark. MGM can be a trademark, and the roar can be a trademark. Okay. Anybody remember the McRib? It's forgettable though, isn't it? Every now and then you will see advertising for McRib is back. Yes? I don't know whether that brings great joy to your heart or not, but having tried the McRib, that just sort of misses the mark for me. What happens with the trademark situation is that in order for you to maintain a trademark, you have to prove that you're still doing business with that trademarked object or name or symbol or whatever. So McRib, and it's every 5 to 10 years, something like that. This means you can't monopolize a trademark. You just can't go up like people used to buy up a whole lot of domain names and just wait for people to need them and then sell them for gigantic amounts of money. Well, the same with trademarks. You have to not only go through a full-scale legal process to get a trademark, but you have to keep proving to the U.S. Patent and Trademark Office that you're using it on a regular basis. So McRib comes back in time to fulfill the need to keep McRib, which is a trademark, to keep the trademark in force. McRib is a trademark. The trademark database has live and dead trademarks in it. Things that people either decided to stop using or they didn't need anymore, or they stopped using so they no longer were able to retain them. Examples of trademark. Yes, is that, yes?
Something like
You know, that would be branching into legal areas I'm not sure of. I only know that if you've had a trademark and it didn't go dead, then you can bring it back within a certain amount of time. In other words, but if it's gone dead, then that's a question for an attorney. Okay.
Actually, Kathleen, you can do that.
Mike?
You can bring back a trademark that has been abandoned or allowed, a trademark that's been abandoned and allowed to go dead. If it's in the morgue and it's not been re-registered, essentially
right.
that's what they call it, as a morgue. If it hasn't been re-registered, you can pick up and reapply for that very trademark for your own purposes.
So
Good.
it's in the
Thanks,
open
Mike.
domain, If it's in the open domain, you can.
All right. So I got a lot of questions about how do I protect my work? How can I keep people from stealing it? How can I use other people's work? It was an interesting thing, and that's why the seesaw struck me. And I couldn't draw the kind of seesaw I wanted any better than this one that I found from Dreams Time. And this is a licensed image that I licensed so that I could present it to you at this lecture. I couldn't take it as fair use because in order to get an unwatermarked copy, I had to license it. And I have a royalty-free license. It's a copyrighted image, but royalty-free means I don't have to pay for it every time I use it. And I can put it on the web, which means I can give it to Jeff in my PowerPoint PDF. You can post it at the site for the students to look at. All right, it's mine. This copyright is mine. What can I do with it? All right. Caleb referred to the rights that contracts will either include or exclude or claim for their own. So the obvious one is you get to make copies of it. And sometimes people miss the point that is one of the rights in copyright. You get to distribute it by selling it, giving it away, or lending it. We lend it in the library. Okay, we lend things in the library. You can make a derivative. This is the modifying and changing. This is slapping Mickey Mouse on the front of it, which shouldn't have happened in that example that Caleb described, but those things do happen. It's putting a banner on your work, it's mirroring, it's changing the colors, all that stuff. That's your right, either to do it or give other people the right to do it. Then there's showing it in public. Showing it in public doesn't mean hanging it in the gallery here on campus. There are some kind of definitions that have come to become commonplace that if you show it in a gallery here, that's not displaying it because it's in the campus environment. But if you give it to Allen Gallup galleries to show it for sale, now you're displaying it. So if it's not yours, you may not have the right to do that. And the other two don't apply to the kind of work we typically do unless you're working on a film, and that is to perform it in public, music, a film, or a play. If it's something that is recorded, like a radio show or a speech or music, you get to broadcast it. It has to be in the copyright law to allow this to happen. And then you have the right that if you put any copyright management information in your digital files electronically, or you put copyright notices on your physical property, then there are penalties for people who take those out in order to take your work and use it on their own in some other way. And then finally, back to contracts. You have the right to give away any of these rights, any combination, none of them, all of them, share them, sell them, lend them, lease them, bequeath them, and negotiate any and all of these things. So it's a really powerful package that you have in your copyright. The same is true of the person sitting next to you whose work you adore and you want to use their stuff. They have all of those rights. All right, do you do any of these things? Do you photograph your work or somebody else's? Are you photographing your work with your cell phone? I don't mean your cell phone, your iPhones these days, you know, your smartphones? Probably, right? Do you email it to somebody? You crop it? You post it on the web? Then you have made a copy, you have distributed it. That's what email does. That's one kind of thing. Handing it out at Comic-Con is another. You've made a derivative even by cropping it, and you've published it because you posted it on the web. And publication becomes important in terms of a time schedule that the Copyright Office has for registration and infringement protection. All right. There's a certain mythology on campus about whether the college owns the work you do. Here's some of the policies. We have an intellectual property ownership policy, I was on the task force that put it together. It was important to me that the premises of copyright were retained, which means that students and faculty own their copyrights and the other intellectual property if you happen to do logos and patents and so forth, okay? The exception to that ownership is that if you create work as a work studies student or a design center intern, then the college owns that work. Or if you are an administrator, Jeff, you're writing memos, you're writing curricula and so forth, not your syllabus, but so forth. But if you're doing administrative work, then the school owns that part of it, but not your own artwork, not your demos in class. I am a work-for-hire employee, if you will. I have faculty and administrative status, but in my case, the work I do as a librarian and an administrator for the college belongs to the college. The work I do at home for my own artwork, writing, and so forth belongs to me. So that's in the policy. Another thing that's in the policy that you should know is that Ringling gets to use your likeness, meaning more or less your photograph. But if you pose as a model in an open-air class, for example, that likeness that other students are drawing of you, that likeness of you as someone, a participant in a workshop or at a social event and so forth, the college gets to use that for what we call ordinary purposes, meaning that we've got to publicize the school and do news events, and we've got to show prospective students how lovely we all here and how happy and what we're busy with and so forth. So that's in the intellectual property policy. Separate policy, several of them as a combination, has to do with the network. And then we have network policies that can limit certain sharing of intellectual property. Usually it's peer-to-peer file sharing. It's typically been sharing software, films, and music that you don't have the right to share. If that ever happens to you, you may suddenly find you don't have access to your email or your network home, and you have to go talk to Dr. Mahmoud Paga in IT while it gets sorted out. He may have received, and the president may have received, a cease and desist letter from somebody who's discovered their content flowing around somehow on the web, and that you seem to be the source of it. And then finally, other policies are this. When we exhibit things on campus, we have freedom of expression, but we are cognizant of the fact that some of the work we do here may be edgy, difficult, controversial, and so forth, and that people who visit our campus and come to our galleries can be forewarned if we're going to exhibit that work. But we don't put that kind of work in open hallways in the library, places where people are going for some other reason. We don't want them to encounter things like pictures of war stories, physical abuse, the Holocaust, and all of that unexpectedly. So that's a policy. It means we don't restrict what we can create here, but we do take care in where we might exhibit it on campus, including the internet, because we exhibit on the internet. All right. So what about when work is not yours and you don't have all those rights? How can you use it? All right, so I'll take a little side trip here just to make a point that copyright is viewed as a monopoly. The law gives the copyright owner a monopoly for all those lists of rights that I explained to you. So it's a bundle of rights. I'll talk about the exceptions. It has legal protection, both when you're registered and unregistered, although it's a different quality. And that monopoly lasts for 70 years, plus the lifetime of whoever created it. Also, copyright can be owned by the creator of the work. Sometimes the copyright publications call it the author. We use creator here because it's more inclusive, but author can also mean artist. It can be owned by the employer who hired you, or the person to whom the copyright was sold, transferred, or bequeathed, meaning it was willed to somebody. So copyright can be by the person who created it or other parties through legal process. All right, so it's not mine, but how can I use it? Now, some of these are not your favorite ways to use other stuff, but it's worth pointing out. One is the work may be in the public domain. And things go into the public domain because they expired. Well, I have a slide next. I can tell you about that. You can get a work from Creative Commons that has a license. Let me try that again. You can use a work that has a Creative Commons license that matches your use. You can license something, as I did with the seesaw picture. You can ask permission. Not everybody turns people down. A lot of people, your next door neighbor, if you love their work and you want to use it somehow, they may say sure. And famous people might say sure, and corporations might say sure. Sometimes it's just hard to get a hold of them. Fair use is the biggest, chunkiest part of the usages that we depend on as artists. For faculty, face-to-face teaching, we get to show films. We don't think about it anymore, it's commonplace. We can show them in class, but we can't show them out on the deck of the student center without getting permission. In class, we're okay. Student life showing films for a film festival, not okay. And then the Librarian of Congress has the right to make some decisions between times when the laws are between the last law and the next law, and the Librarian of Congress can decide some things. And one of the things that was lobbied for and decided was that faculty and students can break the encryption, which is normally a big penalty process, break the encryption on files that are protected with encryption in order to take clips, in order to teach in class or put things in your project. And this helps with media studies especially. Libraries have exemptions. We make photocopies for other libraries. We can only do that because we have this exception. And then there's this thing called the right of first sale. And for artists, this is in the United States especially. I'm not sure that in fact, I am sure that it does not apply everywhere in the world where copyright holds. But you make a piece of artwork, I buy it at the student sale. I don't get the copyright when I buy your work. You still have that. But I buy it from you for $40. I turn around and sell it to somebody else for $100. I have the right for that difference in there. You don't get any benefit from my selling it at a higher price here in the United States. It's called the right of first sale. Quickie on the public domain. Welcome to the smiley face. That's in the public domain. Have a good day. You can't copyright or you can't get a trademark on that. And public domain in this case is the legal definition according to the Copyright Office and the copyright law. Public domain is used in a lot of ways in terms of real estate and sort of common knowledge, but the legal definition is what we're after here in terms of whether something's available. And it can apply to all sorts of things in the public domain. This is why when things go into generic, especially medicines, when something becomes a generic, it's because the patent has run out and all sorts of people can make their own version. And it can happen for lots of reasons. You couldn't copyright it in the first place, that's a possibility. Like a government, if I'm a photographer for the Army, I can't copyright my work and neither can the government. Maybe the person who did it dedicated it to the public domain. One of the first browsers, and I think it was Netscape, Jennifer saying yes, the person who wrote that code dedicated it to the public domain so everybody could try it, develop it, and make better versions of it. They didn't try to capitalize on their copyright in Netscape. Okay, fair use is where we spend most of our time. The law says among the things that you can use as a reason for using other people's work without their permission is for research, scholarship, kind of where we fall as student artists, teaching, news reporting, commentary, criticism, and parody. Think of Mad Magazine and Saturday Night Live for parody. That's what the law says. The amount of language of fair use in the copyright law is extremely brief, say under 200 words. And the amount of language in court cases deciding whether something is fair use is vast. And I have some examples. Fair use, and I have some more slides that tell you what some of the criteria are. Fair use has evolved in the courts. The courts now interpret the part of the copyright law that is vague. So you have judges and you have juries and you have circumstances and you have publicity and all sorts of things that could sway a decision on this. One of the decisions that has become very useful to artists is whether something under fair use is transformative. It's become something so much more creative, bigger, better, different than the original, that the court will allow that there's no infringement there. This is sort of where appropriation falls. There's no word appropriation in the copyright law. There's no, appropriation isn't something we get to do just because we're artists. Fair use means changing and using someone else's work as long as you meet the criteria, and if the copyright holder says, I don't agree with that, then you're talking about legal issues and lawsuits in courts. So these are the 4 factors that are taken into consideration whether something is fair use, and this is why we tear our hair out, because we're never sure what grounds we're standing on. You have to decide in every case. And there's some checklists that help you decide whether something can be fair. You can't pick one of them and say, well, I am not going to make any money from it, so it's fine. It's like, I'm not going to make any money from it, and I'm not taking the heart out of the work, the most important part, and I'm not taking fictional work. And there's several things like that you sort of go down a column and decide, what are you going to use this work for? That's not just making it a copy. You notice I'm going fast over this because I think giving you the highlights will help you understand where you need to learn, or where you're interested in learning some more. And you can follow up with some of the resources we have. So I've included here, and again, I'm giving this to Jeff for your professional practice website. Transformative use versus appropriation art versus making derivatives. Here's some definitions you could come back to. Another way we can use work that's not ours is through the Creative Commons licenses. Work in the Creative Commons is copyrighted, and then people will assign a certain level of use that they're willing for everyone else to have without seeking further permission from them. There are 4 major elements of Creative Commons licenses, These symbols are kind of recognizable once you spend time in Creative Commons kinds of databases. One is, you can use it any way you like as long as you give me credit. That's the first one, attribution. You can use it as long as if I'm sharing mine, then whatever you make, you have to share too. It has to be non-commercial. That's the 3rd license, if they pick that. And the last one is, you're not allowed to make any derivatives of it. You can go ahead and use my work as is, my beautiful picture of the Siesta Key sunset, but you can't change it. And an artist, a creator, can pick any number of licenses and make combinations for how you can use their work. We send you generally to Flickr and its Creative Commons database for an easy way to find things and download, and those files are typically in multiple sizes for whatever your purposes are. So there's a search engine, and we have a link from the library website. Again, this is Flickr. This is one of the places you can find Creative Commons material. Not limited to images. We're talking images, but there's music and film, and Jennifer is one of our experts in Creative Commons, and if you'd like to chat with her about it, she's available. I got a lot of questions about how can I protect my work. Depends on how far you want to go. I always recommend at this point in your career that you put the copyright notice on the work that leaves your hands. It's not required. It used to be required, and if you can find some copyrighted work, if you can find some creative work from earlier decades that didn't have the copyright notice on it, it went into the public domain. We have these extravagant matrix-type charts that help us say if it was done between this date and it didn't have a notice and it wasn't renewed, da-da-da-da. It's much easier to find that with things that are made that are textual, meaning written works, possibly film works. Easier to find that information than it is with images, because photographers and artists didn't put any copyright notice on things. I bet you still don't, right? Probably not. Registration, I'll talk to you about that in December. But this is the legal form of saying, this is my work on this date, I'm sending in copies of it to the Copyright Office, and if anybody challenges me on this, or I have to challenge them, there's an official record of that. Keep track of your process, all your assets that you use, so that, as Caleb says, sometimes people are creating things that look immeasurably alike. I mean, how many different ways can you can you paint a sunset? If you keep track of your process, you can possibly convince someone that you did not infringe their work to create your result. Because coincidences happen all the time. You can put digital copyright management information in, and I have seen in Photoshop where that's a possibility. And that's metadata. It's invisible to the viewer, but it travels with the file. And if somebody takes it out in order to steal your work and use it otherwise without your permission or payment, that if they take it out, they get a separate special penalty levied on them just for taking that information out, as well as any other copyright information you put in. You can put a digital watermark. And this is gonna sound like nonsense to you, but once something goes on the web, people can steal your work. It's not legal, but they can physically do it. You already know that, right? So if you're truly, deeply, extremely concerned about people taking your work, you'd have to keep it off the web. I don't know how you live your life as an artist these days if you do that, but that's one extreme. And then seek legal action, legal advice, and take legal action. These are like from most obvious and easy down to more serious and in-depth suggestions about how to protect your work. Just an example of the copyright notice, how you set that up. Next time I'll talk about the registration process. And some have asked, what happens if my work is infringed? The Copyright Office does not police any of this. In fact, when they give you a copyright certificate, unless they see something obvious in your work that tells them that this is probably not original to you or it's not original enough for copyright, they just go ahead and give you the certificate. And it's only when someone else says, I think that's my work, that your copyright registration comes into play. They're not a bureau for monitoring what everybody else is doing. If you don't have registration, you can still do these things. You can still ask that these things happen, that people are stopped from using your work, that the work that they've created is taken back, that any profits they got from using your work go to you, and anything else you suffered. And if you register, you can take it into a federal court, into a court of law, and there are statutory damages where the law already says how much penalty they have to pay, and you might get your attorney's fees. Okay, I don't know if anybody still is under the impression that there is a usable poor man's copyright. This dates from way back before the web and when copyright registration was required. And this is the idea of putting your work or copies of your work in an envelope, sending it through the US mail, and keeping it as documentation. You may find it useful for record keeping, but the Copyright Office does not recognize it as having any legal standing. Don't depend on it if this is all you've got going. Social media, our friend. We are connected. They have attorneys. They write the longest possible terms of use, and they, right up front, they say, you own the copyright in your work. It's just as Caleb said, you own the copyright in your work. But by the way, we say, we get to do all these things. So when you're posting, some things they need to do, they need to resize your images, they need to distribute them, otherwise your friends don't see them, and so forth. But then they say, and we can use them in our promotion, and we can sell our company, and they can have new rights and all of this. The most you can do is go in wide-eyed and having read the terms of service, the TOS on that. Here's another wide-eyed thing you need to understand. When you come to Ringling and you come in and you get that student handbook, or you get a form to sign that says you understand the student handbook, in there, Ringling has a license to use your work. Well, the work you did as a student here, to put it in brochures, show the accreditation committee, promote the college, interest the donors in us. So we've claimed rights in your work as well.
That's
Non-commercial, that's right. That's right, non-commercial use. It's not for us to capitalize on your creative assets. It's for us to be able to show prospective students what great work is done here, to boast about ourselves, to put ourselves in news releases, to put it on the web. If we didn't have that right, we couldn't put any of your work on the web. Okay, and let's talk just briefly about using images. We all use images. How do we know what various engines look like? What goes on the front of a fire engine? What skies look like at different times of the day? Use of images for reference is commonplace. It's expected. We do it all the time. The difference is that using the reference as is, either copying from it or portions from it, or just taking it and putting right in the middle of your graphic design project, if you're a designer, or an advertising project, you get into the issues of copyright and the rights involved. I think you all understand that. I know that a lot of you commented in your question section that you know a lot about copyright because of what your faculty, and especially Mike Hodges, have been teaching you for quite some time. Okay. Mike says no, the shaking of the no. Do you want to go any more than shaking the head?
Well, I have the test papers to prove it.
Okay.
How much they do or don't know.
Oh, okay. I was thinking there was hope for America going on here. Okay. All right. So let's go back to fair use and let's look at some images right now. We show these images a lot because they're very famous cases. And in both cases, it's like artist against artist. And the top is a photograph that was printed on note cards. Art Rogers did this. And Jeff Koons, who's known as an appropriation artist and other things, he's very successful, by the way, he sent that picture to his fabrication studio in Italy and had them make up three-dimensional sculptures based on the pictures on the left. And Art Rogers sued him, and it was up to the court to decide. You may already know the answer to this. Do you know who won the lawsuit in this particular case? The answer is Art Rogers, the photographer. Jeff Koons made what I think of as a cornball defense. He said to the court, this is fair use because it's a parody. And the court, the judge and the jury said, we don't see that. And he had made over $300,000 on selling 3 of the sculptures. So there was some out-of-court settlement that benefited Art Rogers in there. On the other side, Jeff Koons again, there's a photographer who took a picture of these feet, and they're in an ad in a magazine, and Jeff Koons, you might see, took those 2 feet out of that ad, and they appear in the mural below. Do you see those? Do you see those particular feet? So the magazine and the foot model sued Jeff Koons and said, hey, that's our stuff. And in this case, the court said, we think that that's fair use. We think it's transformative. Jeff made it something different, creative. It made it other than it was originally. It's transformed it into another purpose. Not everybody agrees with the decisions, but these are things that go into case law, and future court cases make decisions based on this. On the left, a photographer took these pictures. I can't remember Carrie's first name. He published these in a book. The book was published and distributed. Richard Prince bought copies of the book, took the pages out, added things to it like this air guitar, and whatever the masking is on the face, framed them, sold them in a gallery very successfully. The photographer sued Richard Prince, and the courts have been going back and forth. They found in favor of the photographer for a while, then the court was reversed. They were finding in favor of Richard Prince, back and forth, and right now it's sort of Prince ahead by a nose, if you will, as being transformative. This is one of my favorites because I love the picture on the left. Labius Woods, a German artist. This was published first in Germany, then in the United States, and Labius Woods went to see 12 Monkeys, and he saw some of the scenes that you see on the right. Do you remember 12 Monkeys? Bruce Willis is called in for interrogation. He's sat down in that chair in the large warehouse-looking space. They lift the chair up. The large orb at the top. He's being questioned by the examiners and so forth. And Labius Woods sued Universal Studios, and at first they said it's a coincidence. And over time, they had to admit that their art director, Terry Gilliam, had seen the Labius Woods book and drawing and thought it was perfect for his movie and went ahead and decided to do the scene based on it. That makes it a derivative, and was already in distribution. And Labius Woods was in a good position because he could have had an injunction and had them take back all of the copies of the film soon after it was distributed. What do you think he did? Show me the money. Jeff's got it. Show me the money. So I think we don't ever know how much these things are as a rule because there's usually a gag order on them. But Labius Woods benefited out of that situation. You can name this person, right? You know this, the Hope poster was done by Shepard Fairey, a street artist who became well known for like Andre the Giant and so forth. And then the Hope poster came out, and so the Associated Press sued for infringement. And the picture that was involved, that was said to be the basis of the Hope poster, and therefore an infringement, is the one on the left by Manny Garcia, taken in 2006. The poster was published in 2008 during the presidential campaign. Manny Garcia didn't even know at first that it was his image that the Hope poster was based on. Shepard Fairey, I've heard him speak on, there's a pretty good, and we have it as a link for you, pretty good YouTube video where he's talking to a class of attorneys about the whole process. He's spoken a lot about this. He claims fair use now. He started by saying, I was inspired by many pictures of President Obama, who was not president at that time. I was inspired by. Well, in fact, he had seen this photo and decided this was the one. So he was not really playing honest at the beginning, but there was a strong support for his use of this image because it was viewed as transformative. It was not the same thing. And I listened to what the attorney for Shepard Fairey said, and there was quite an interesting argument about what a documentary photographer does and how that they are supposed to get the facts without any emotion in the picture, without any commentary, nothing, no editorializing, so that this would make this not really a protected image. It's gone back and forth, and both of those parties settled out of court. We were hoping it would be settled in court so it would be precedent setting, because Shepard Fairey sued them for suing him, and it was really back and forth. The original of the Hope poster is now hanging in the Smithsonian Museum.
Just to follow up on that, that was settled out of court, but Shepard Fairey was convicted of tampering with evidence and
Yes.
lying to the jury and fined $30,000 and serving probation. So he didn't get off scot-free, and I imagine that every poster that he's selling still, there's a percentage that goes to Associated Press and Manny Garcia. There was a law student who did a comparative of this with other cases, including the Coons cases, and determined after 18 pages of research, writing, and the such, that he would have been convicted had they gone to trial.
You notice in every case when we're talking about an artist using another artist's kind of work, we're talking about a lot of time and money and legal support and everything spent on these things. It's not like we get a pass on them when we go after people who we think are infringing. All right, so what do you think? So this is what came about after the Hope poster. And there are hundreds of these. So what's the deal here? Are these okay? I'm going to offer the opinion that if the Hope poster turns out to be okay, they didn't do an injunction, they didn't take it down, they didn't confiscate all the copies, that if it's okay, then it's okay for people to make a parody of the Hope poster without seeking permission of Shepard Fairey. Surprise! Now, he actually supports this. He's fine with this. But how else can he be? Because he's been outed, right? Okay. Jake, would you like to come up? And I have, Jake, I put an image, a photograph, up next to your image, not meant to have any commentary on my part, but just for a point of reference. So Jake ran into an interesting experience, which is intellectual property law without being copyright law. I'm going to give you the, yes, you have to speak right into it like karaoke.
Okay, so I don't know, some of you probably already know, but the way the Adobe Awards works, they have 3 rounds. So the first is like just everything that's been internationally, and they choose a handful of those to go to the semifinalist round, and they pick 3 semifinalists into the finalists, and they pick 1 winner. And the first thing they do, they send you an email if you get into the semifinals, asking if you use either a company logo or a celebrity likeness, then they want you to get the release rights to the piece. And I had no idea first how to go about that. But with some help from Kathleen, she suggested contacting Bryan Cranston's talent agency and seeing if anybody there could help out. And so I called them, and it was a dead end. Like nobody even responded. I'm sure they didn't hear. And so the next step was I tried emailing the AMC network, different people at AMC, and about a week or so went by, and I got nothing from them either. And the deadline was approaching. They wanted you to resubmit like a physical print of this piece, mail it off to California to Adobe for them to judge again. And so I figured I had nothing to lose by trying to contact some of the people who were actually involved in the show, and I got a response from one of the directors, Ryan Johnson, and even he was like, I have no idea who to contact about release rights. So I was about to give up, but I asked the person who was coordinating the Adobe Awards show, or the competition, and said, if you don't have the release rights, it's okay, you can mail it off. We'll deal with that later when it comes to say that you're working on getting the release rights still. Because their other option was to alter the image so that there's no longer a likeness label. I considered that briefly, but then I thought it would just be kind of meaningless, because if that's not Walter White, then it's an anonymous man serving some blue jello or something. So about a day or so after I actually mailed it off, I got a call from the vice president of marketing at Sony Pictures, because Sony Pictures is the studio and that produces the show, and they actually own all the release. They own the rights to everything, not AMC. And so the conversation was going pretty well. He was really nice, really friendly, and I thought, okay, this is what I'm going to get the rights. And he says, yeah, normally we don't have any problem giving students it'd be okay for things like this. He says, but the snag, and he had read, before our phone call, he had read Adobe's terms and conditions for entering the show. Adobe wanted, I think for about 2 years, they could use the image however they wanted, alter it, manipulate it for advertising for Adobe products. And I'm not entirely sure how they do that, but that was the problem for him, and that was the only thing that kept me from getting the rights. So yeah, I wouldn't really recommend entering a portrait of a celebrity, I guess, into a show like this. Unless you're only, I mean, it still maintains its semifinalist. You know, it can go as far as the semifinal round, but it won't go past that if you can't get the release rights. That's about it.
Great. So what Jake ran into was a state law, the right of publicity, the right of a person to have their own likeness, their persona. And let's think of Charlie Chaplin and the persona, or any of the attributes. When you think of Charlie Chaplin, you think of the derby hat and the cane and so forth. Those are part of the persona, and the likeness is something that you have as an intellectual property if you're well known enough to make the money off of that. So that's a state law. The right of privacy is somewhat connected to it, and that is you have the right not to have your picture splashed everywhere, not to have drawings done of you without your permission and posted and so forth. And they're somewhat tied. One has to do with celebrity status and one has to do with privacy of the individual. So a few quick images as we close up here. You can tell that's Barbie. Barbie in very distressing circumstances, very un-Barbie-esque. And Mattel sued the artist here, and the court said, get over yourselves, it's a parody. Nobody would confuse what's happening to Barbie here with your Barbie and your fashion clothing and all of that. There's no confusion here. It's a statement. Here is a piece of work that's considered transformative. It's a collage artist, Barbara Margulies. Here is outright plagiarism, if you will, and this comes up now and then. Do those look alike? One's a little different in color, isn't it? A filter was used. Okay, so Instagram recently ran a contest, and the plagiarizer won the contest with the image stolen from another photographer, and was blatant about it, said, what's the big deal, more or less. And so I don't know what legal action has followed. Samsung took the award away. Well, okay, thank you very much. But this is not fair use, it's not modifying it, this is plagiarism. So finally, we want you to know that we have both in its initial stages and always in progress, we have an online research guide for you about copyright and intellectual property issues where we put resources, things like tutorials. You can pick and choose among the styles that you like. I'll put up some of my favorite books that I use. I have about 5 I go to all the time. Some of the same points I made in the lecture are up here on the site. We filled it out with more things. Thank you very much for your participation and your attention. I appreciate it.